Hello, hello, hello. This is Attorney Mike Gravlin, a little bit early. And as you can see, I've got the DUI guy here. Say hello.
What's up, you guys? How's it going?
We've got a DUI today, and I was on, I call you Larry. I'm sorry, but I was on Larry's show the other day. That was like a total surprise. I was just in your comments, and then I hopped on, and we had a ton of fun. I had this clip, a viewer had sent it to me, and I'm like, I really want your thoughts on this. Okay.
All right.
He's in some undisclosed location. I said, just hop on anyway. So that's why I said, let's get this thing going and get started with the clip here.
Record. I have not seen this yet.
Is it not doing it? I did the wrong clip.
On the record and on YouTube on State v. Crouchin. There's two matters on, and I asked Annie earlier today to calendar Mr. Crouchin's third case, the ignition interlock case, because he's scheduled to make a court appearance next week. It's a state case, so same prosecutor's office. Mr. Amoyan, you're representing him on that, and what the district court bench is trying to do is keep people and attorneys from having to go to multiple court dates all the time. So unless you object, and you wanted to go to court in front of Judge Parcher, would just have all three cases go together.
That's fine.
So since we were in court earlier this week, I spent some real time looking at the history of the cases that we have here. And I want to lay that part out first, and then obviously allow the attorneys to make any arguments. So Mr. Crouchin was charged in the 9Z case. The incident date was December 28th, 2019. He made a first appearance a couple days later, and because he'd had a prior, I think in 2014, that was reduced, the judge at that time imposed a $5,000 bond, and because of the prior offense, imposed an ignition interlock requirement, which is fairly standard. That's the lowest level of the additional supervision that we have. Everything was fine on the case for about 6 months, and then the first pretrial release violation happened. So pretrial release violation number 1, and it was a big one, the new DUI charge. The incident date on that was July 19th, 2020. He was arraigned the next day. Bond was set on the new case at $10,000 and raised to $10,000 on the original 2019 case. The ignition interlock requirement remained.
Thank you, Uncle Artie. All right, I just wanted to give everybody a little overview. We're at what's called a show cause hearing in the state of Washington. Larry is a DUI attorney in the state of Kentucky. Does this look familiar to you, this sort of what's gone on so far?
Well, at this point, like you said, it being a show cause, it sounds... So show causes come in like two different flavors, at least from what I've seen, okay? You have the show causes that are just a basic, you have to show cause why you need more time to pay fines, court costs, and so on. But sometimes a show cause mirrors almost, it's kind of like a contempt light. And this is starting to smell like a contempt light, maybe even not a contempt light, maybe just a pure contempt hearing just called show cause. Maybe Washington just calls them show causes. But like show cause is usually just a very, very basic, soft hearing, unless you're there to show cause why the court should not be putting you in jail. That's right. So that's where show cause can like be several different things.
That's the way I see it.
And the way
I'm not familiar with this because I don't do it every day, but yes, that's.
Yeah. I mean, the way this is starting to smell is pretty bad.
Violation. He isn't tried on the first one, and he goes and picks up another DUI.
Right, and this is a show cause, I'm guessing, without even knowing how this is going to end. It's starting to smell like they're either trying to lock him up, take away his ignition interlock privileges, or both, maybe something else. But that's what it's starting to smell like.
It's almost like you've done this before.
And Scram was added. Pretrial release violation number 2 happened in April, or at least it was filed in April of 2021. There was a positive Scram result.
Real quick, so I can explain, because some people may not know what a Scram device is. I forget the exact acronym, but it's a continuous alcohol monitoring, remote continuous alcohol monitoring device, basically. It gets put on your leg, usually, and it's kind of just like a one of those house arrest thingies you get put on, only this one also tests for alcohol. So it actually monitors your skin, because if you consume alcohol, you will excrete some of the alcohol through your skin.
I was wondering how that worked.
Yeah, and it detects if it detects alcohol. Like if you spill a beer on that thing, obviously it will start going off. So that would be like a technical non-violation violation. But a real violation is when it detects your skin, and if you've been consuming alcohol and it detects alcohol on your skin, it'll report back to the agency saying alcohol detected, and that's when you get in trouble with the court if you have been drinking when you're not supposed to be drinking.
It's funny how much you're foreshadowing this, and I happen to know, because you and I talked about it, that you have not seen it.
No, I have not. Yeah, this is just...
You can see it coming. That's what made me think
of you. Away,
I felt bad for this defense attorney. I'm like, when you have a client do this to you, I mean, what do you say? And he's valiant. He's
There's
valiant.
There's only so much you can do. You can't change the facts.
No.
At that time, pretrial release noted, and that Mr. Cragen said that a friend threw beer on him. He was allowed to remain out on the same conditions with no change.
By the way, that didn't happen.
Pretrial release violation number 3 happened a couple of months later, another positive Scram result. And the positive Scram result was over a period of 3 days, from May 29th, May 30th, and May 31st. And I didn't look at this specifically, but I believe that would have been Memorial Day weekend of 2021. Pretrial release.
They're spilling a lot of beer
indicated Mr. Cragen said he'd used a homemade...
What's that?
I said they're spilling a lot of beer on this guy. May 29th, 30th, 31st. How much beer are they going to waste on him?
He just can't stay out of the way of alcohol
remedy, a rag that he had soaked in alcohol and wrapped around his leg.
What?
He was allowed to remain on Scram. He was not taken into custody, and his bail was not increased. That was pretrial release violation number 3. Pretrial release violation number 4 happened a couple months later in August of 2021. Another positive Scram result. At that time, Mr. Cragen said that he had used some off mosquito spray, and that was the reason for the Scram positive. At that point, and I remember that hearing very well, I indicated that Scram was not working for Mr. Cragen. So we took him off Scram. I did not take him into custody. I did not make him post additional bail because I believed that Scram was not working. We moved him over to random UAs.
What a nice judge.
Pretrial release violation.
Oh, he's too nice. And he really is. And he's also a sharp guy. What are random UAs? What's random testing versus Scram?
Random testing is when you're they call you on a Tuesday and you have 30 minutes to report to the location to be tested for drugs and alcohol.
So, I mean, come on, Judge. You couldn't buy any of these stories. And he doesn't, you can see now. But he's just giving them another chance.
Way too many. This guy, like you said, he's way too nice.
That's essentially what we are here for now. The allegation.
That's another thing. Well, another reason I thought of you, I'm like, oh, this ain't happening in Kentucky.
No, well, judges are tolerant, but come on. Next, what are you going to do? Your sister took a tampon, dipped it in alcohol, and threw it at you? Come on. What's the next one? What's the next excuse?
Twofold. One, that he had stopped reporting for a period of time for his UAs. Mr. Mullion spoke to that earlier this week at the hearing. There was an admission on that. He had a sick family member, his grandmother, and made the decision to go back to Russia to be there for that.
Wow.
Which, I mean, by itself wouldn't probably be a problem with me. But the other part of the pretrial release violation, and the reason it was set over to today, was because the new law violation of driving while suspended and ignition interlock violation, which has been added to our docket today. So we have all 3 cases. Previous finding of probable cause that occurred on that matter, I printed out for counsel off of liberty, the short citation and narrative, and I know that the prosecutor's office got him the discovery, so he would have it today because that was an issue. So what we have here is 5 pretrial release violations in about every possible way you can have one.
Yeah.
The initial conditions that were set in 2019 told him not to drink, and he could only drive if he had an ignition interlock violation. Well, there's a new DUI and a new interlock violation charge since the judge ordered him to do that. The Scram, which I believe Judge Osler in July of 2020 put him on at his arraignment on the second DUI, was designed so that he wouldn't consume alcohol, there wouldn't be alcohol in his system or around him or on his body to try to keep him sober. Still, he was ordered to have the interlock, and we had all the problems on the Scram. So I threw up my hands at that point after 3 Scram violations and moved him over to UAs, and that is not working either. All the while, an order not to drive unless he had an ignition interlock device remained in effect on both cases. So,
Oh my God, Gia.
he'd made an admission that he stopped doing UAs for a while and left the country. And Mr. Moyen, I don't find it necessary for you to make any kind of admission or denial about the ignition interlock case. I mean, it's a pending case, and he's got a right to remain silent, and you have a right to defend him on that case. And I think a finding of probable cause is enough at a pretrial release violation hearing when the standard of proof is obviously much lower than beyond a reasonable doubt. He's still presumed innocent of the charge.
That's where it gets very inside baseball right now. He gets popped for the first DUI. All these violations are before he's tried for his first DUI. Then they get real heated right now about what they have to show because they're just having probable cause hearings. He's not found guilty of anything.
Right. And the standard is super low, as the judge already said.
Yeah, and it just gets hot. And the reason why, I think the judge is very smart, a good judge, and I think the defense is very good, but that's all the defense attorney has, is to get hyper-technical about, hey, he hasn't been convicted of anything yet. And that's where we go.
Let's see. Yeah.
So that is the history of these 2 cases and the 3rd case that's been added, but that's not a pretrial release violation, and he's not on bail on that. And so I'm really focusing on the other 2, but wanted to have all 3 of them together. Mr. Riston, what is the state's position at this point?
State's position is that the defendant has had every chance possible. The state doesn't even know what it could suggest.
The state doesn't even know what it
short
could
of remanding to custody until the case is resolved.
Reasonable, extreme, but reasonable.
Mr. Moyne.
Your Honor, I don't know if I understood you correctly. I think what I hear the court saying is that the court wants to move forward on essentially a contested release violation as to the new criminal conduct today based on the probable cause affidavit.
Well, it's the pretrial release violation is not completely contested because you admitted that he stopped taking UAs when he went to Russia. So that's an admission on the 5th pretrial release violation.
That is correct.
And me trying to protect his rights and your opportunity to defend him and not have to make statements about the pending case, I was simply telling you as a courtesy that after a finding of probable cause on a new criminal charge, I believe under the court rule that is enough to move forward on a release violation. If you want to talk more about the pending criminal charge, you're free to do that.
I don't want to move forward in regards to using the alleged pending criminal charge as a violation, but
I mean, this is where, and here's, I get my law nerd shirt on for this right now, and you get this, but I mean, think how rough this is. Effectively, he's sitting on, he's using the 5th Amendment on other violations during the pendency of this case to protect him from yet more violations. Mm-hmm. That is what is going on right now. Mm-hmm. Technically, makes a lot of sense, and I understand it, and the judge understands it, but wow, what a horrible position to be in.
Terrible.
I do believe there's a basis to object to the court doing that.
Go ahead.
Sure. So there's a couple cases I think the court would have to look at. They're all Ninth Circuit or they're all federal cases. They stem from Morrissey versus Brewer, Morrissey, i.e. a Morrissey hearing, 408 U.S. 475. It found that there's a minimal due process requirement.
Setting federal cases in the
before
DUI.
somebody can be violated.
I'm telling you, I love this guy
violation.
already.
That was extended to probation violations in Gags Now versus Scarpelli, 411 U.S. 778. And I believe it applies to pretrial release violations pursuant, even on the reduced standard of proof, pursuant to the United States versus Comito, which is a Ninth Circuit case. I cited it last time. It's 177 F. 3rd 1166. So I would argue that under Comito and the cases that I've cited, that my client has a minimal due process right to confront the allegations against him.
Yes.
And that if the state intends to ask the court to make a finding that there is a release violation, that they need more than a probable cause statement. I understand the court's made up its mind already, but it seems to me that under that line of cases,
I love how you
does
just
have a
called the
minimal
judge
due
out. I know
process
you already
right.
made up your mind, but then
And
you
without
changed it
actually
anyway.
presenting evidence, the court can't just rely on an affidavit filed in court.
Let
Yes.
me ask you this, Mr. Mullion.
Sure.
Yeah, I mean, this guy's top notch in the sense that, I mean, you run the gamut in this sort of thing, but you're not going to find a lot of attorneys who are really making serious constitutional due process arguments. I mean, it's sort of in the mix on common things, but he's citing cases and making sense on intricate stuff. Like this guy had to go get a good attorney for the mess he created.
But I'll be honest with you, man. This is already starting to sound a little fishy because I had a few of these ignition interlock hearings back in my day myself, and let me tell you, what they need to do, what the state messed up on. I'm trying not to curse too much because this is really getting under my skin right now. What the state has not done, and I was looking for this to happen, but it never. I thought either it already happened or it's about to happen or they're going to schedule it to happen. None of those three things happened. You can't just use the allegation of a violation, read it into the record and say, yeah, it looks good to me. I don't care if it's 5 of them or 12 of them or 567 of them, okay?
Yep.
You have to put either a witness in that witness box. You have to protect the record. You have to build a record. You have to show, this is all hearsay. Everything that the judge just read literally is 100% hearsay. The hearing,
he's not seen this. That's exactly where this goes right now.
The hearing that I held, the hearings that I held, and there's one in particular that comes to mind in my head right now. They couldn't procure the witness in physical form because my question was so technical. They couldn't just call the Scram guy or the ignition interlock guy. They phoned like the ignition interlock expert who's like in frickin' Iowa. And we did a telephonic, this is way before COVID.
Mm-hmm.
We did it over the telephone. I said, I have no problem. I'll ask him everything I need to ask him. And the state was like, we want to lock your client up for 30 days. And I said, I have no problem if this violation truly occurred, put the expert on the line. And I grilled that expert so much to the point where the judge was scratching her head going, I'm not sure a violation occurred here because the state can no longer, you didn't prove it. The expert was, I got the expert to admit to the judge, that certain things were not met and they could be construed as something else. And he admitted to them. You have to understand what you're up against, how to approach it, what you need to say, how you need to say it, what you need to ask, how you need to ask it. And when you have all your ducks in a row, you go in through the ringer. And if the state has a violation and they can prove it, then your client may go to jail. It's still up to the judge to decide. Even if there is a violation that has occurred, granted, this case is a little different. There are 5 of them, but they haven't proved a single one with
still hit the
testimony.
nail on the head. Procedurally, they haven't gotten there yet. That's the whole fight. They need some evidence. You're right. You're just bootstrapping on violations, but there's been no evidence anywhere yet.
Exactly.
He's guilty. I know he's guilty. But
Probably. Probably, but you got to prove it.
Absolutely.
When he was charged with his second DUI while on release,
Be right back.
isn't that exactly what happened? A judge reviewed a probable cause statement on a second DUI new case, unlitigated, found probable cause, and changed his release conditions on the first DUI case, upped the bail $5,000 and upped him to Scram. It's exactly what happened. So your argument is that Judge Osler in July of 2020 on the newest DUI case wouldn't have the authority to change the release conditions absent some evidentiary hearing that you are arguing.
Your Honor, I'd point out that for many years, especially when you were still practicing law as an attorney,
what you said.
Washington relied in domestic violence cases on an affidavit sometimes as evidence in a trial. And then Crawford versus Washington came along and said, you've been doing it wrong. So the reality is that even though a judge previously did it on an unrelated issue in Mr. Kreitch's matter, doesn't mean that he still has a minimal due process right.
In front of
and if
that
that issue is raised, it should be considered. But
Well,
I'm guessing that the client had a different lawyer when he was in front of that other judge. That's why that argument was not brought up. That's my guess.
yeah, that does make sense. I actually thought that when I first saw it. I'm like, why didn't we have this fight with the other judge?
Yeah,
But yeah, you're probably right. He probably upped it because he keeps having problems, and he knows he's in a bad spot right now.
yeah, and he needs like a machine gun lawyer, not a pistol.
Yep.
clearly,
So if he got a third DUI, I would have to leave his release conditions the same until whatever type of hearing you are discussing. This isn't a Smith affidavit in a trial. That I'm frankly glad that ruling was made. Very different situation than we have on release violations.
I would
But
imagine that's
Mr.
Washington.
Moyen, that doesn't
Yeah, I
make
have
any
no idea
logical
what
sense. The
that is.
defendant can commit crime after crime after crime after crime, and a judge would be powerless to do anything on it on any of those prior cases that they'd set release conditions. I guess they could set the release conditions so high and outlandish on the brand new case, but that's not what 3.2 is asking of us. I mean, it's asking us to give the least restrictive condition. And the reason I wanted to do the history on Mr. Kreitchen is because we have a history of trying to do the least restrictive condition. The bail was set.
Is that what you have in Kentucky too? Is that the standard that they're going to cite? Least restrictive condition, or is this a Washington thing?
Smells like a Washington thing, but I'm sure we have just different language. I just can't remember it right now.
Same concept, right?
Yeah, but yeah.
And the ignition interlock requirement happened way back. Now, bail was set, so that probably wasn't the absolute least restrictive condition, but the interlock device would have been. And then with the second DUI, 2 pending, 3 total since 2014, bail, Scram, you're out of custody. You've been out of custody now throughout the term, the pendency of the pandemic. And I had to then take you off Scram because that wasn't working. So every least restrictive condition that we've tried has not worked in these cases. I want to follow the court rule.
I would argue that taking him off of Scram and putting him on random UAs has worked because he hasn't been consuming controlled substances or alcohol.
Well, he left,
washout,
wasn't taking UAs, and anytime a person is required to have an ignition interlock device on their car and they drive without it, we don't know whether they were sober or not. Maybe their UA maybe they didn't have to take a UA till 4 or 5 days later. We don't know, Mr. Mullion. That's why when attorneys argue, well, ignition interlock violation's enough, sometimes it is on DUI cases, but I've always wondered, well, if a person decides not to drive a car, they could sit home and drink all the time in violation of their release conditions. That's an argument for another time that doesn't apply to this case, but we
now
don't
he's
know.
going into
When he leaves for
hypotheticals,
Russia and doesn't take UAs, and when he's allegedly driving, been charged.
What are you saying?
He's going into hypotheticals now. Like,
Yeah.
in theory, one could argue this judge went from like clear territory to maybe territory, and I very much dislike that. I think, honestly, the judge is just really, really frustrated with this guy, and I get it. I totally get it. But he can't let his own personal bias taint his view of the case.
Well,
charged and probable.
You sound a lot like this attorney. It's funny. You're just instinctively like seeing which makes sense. I mean, you know.
Yeah, it comes with the territory.
A good attorney's going to think like another good attorney. Yep. Yeah, that's going to happen.
There you go.
Without an interlock device, I don't know what he's doing.
This is Minority Report, lawyer version.
I don't think any of us can know.
Okay.
What are you asking the court to do?
I'm asking the court not to remand him into custody. If the court thinks that UAs are not adequate under the current circumstances, I guess we could try Scram again, but he obviously had a problem with Scram. He's got a job. He's got a life. I mean, I know the court says you don't know if he's been drinking or not, but, you know, since the Scram bracelet was removed, he hasn't had a dirty UA, and he has taken some until he left for Russia. So, you know.
When did he leave for Russia, and has he taken one since?
Well, he checked in with his PO. I don't know if his PO asked.
We were talking about UAs, Mr. Mullion. When did you leave for Russia? When was the last time you took a UA?
It was right pretty much before I left, and then when I came, right away, I had two right in. First one was Friday, the second was on Monday.
When did you leave?
The 11th.
January 11th?
Yeah.
It's March 11th today. 60 days, not one UA.
Oh, I think you had a UA when you got back.
Well, I had two UAs when I came back. Right, first one's right, like literally the next day when I came, and then over the weekend another one. So two.
But then they haven't had you take any in how long?
3 weeks. Almost 3 weeks, not fully 3 weeks.
So, I mean, he took two UAs when he got back. He took a UA before he went. So
The judge can easily revoke him, like right here, right now.
There has been at least a history of taking UAs. Maybe there's a window of opportunity when he was in Russia that he could have possibly used alcohol.
The
not been
UA
detected.
people, I'm sorry, I keep making you hit the pause button. It's just because it's freaking frustrating me, man. They need a way. You can't just go off of this nonsense. You have to have the UA, somebody from that office going, yeah, he did report on this day and he did not report on that day. I mean, he's just holding like a piecemeal evidentiary hearing. I don't know, man. This just.
I know exactly what you mean.
I'm not even trying to protect this guy. I'm trying to protect his rights. You know what I'm saying? Yep. Because everybody deserves their rights protected, and to me, this is not happening right now.
You need testimony. You need someone to come in and say, "I did the test, a lab, whatever. He was dirty on these days," and then they're going to say, "Okay, fine, that's a violation," and everyone.
But he didn't show up. He was absent. You know, from January 11th to March 7th, he had no tests. Now it's in the record. The judge has it as evidence, and now it can be used, you know, to revoke his bond and lock him up. And then the judge is right. He deserves to be locked up. He disappeared for 2 months or whatever.
Right.
But without it, you can't just, you know, you can't create evidence from the bench.
Right. I also enjoyed the defense attorney's argument right here, and he knows, but this is what he's got to work with. He's like, he might have had an opportunity to drink while he was in Russia.
Whatever. You got to prove it, motherfucker. Sorry.
Right.
But, you know, I don't know what you want me to say, Judge. The reality is, here's a guy who, other than some things that happened in the past, hasn't had a huge history of use of alcohol and driving. There's an allegation of driving right now. We I think there was a point where we suggested there was another device available. I forgot what it was that had been suggested by the Scram people.
It's called the other company we used called it a Bart device. And essentially you carry.
Have you ever heard of that other device, the Bart device?
You carry it around all day. Your first breath test. I sampled one of these for our DUI court. I was the guinea pig for this type of device. I think my first breath tests in the morning were around 7 or 7:30 or 8 o'clock, and the last ones were around 9:30 or 10 o'clock. And you carried this device around all day.
Wow.
And it usually went off between 6 and 7 times, and you blew into it.
And we did
With
see-
Mr. Kryachin's history of
They
not
found-
even
It's
being
a
able
walking
to be on a
ignition
scram
there.
without having beer thrown on him, to put off mosquito spray, and to put a home remedy of a rag of alcohol around his ankle, I don't have a lot of faith that he's going to do great with his box 7 times a day.
Yeah, the judge just lays it out right there. That's his frustration. But the counter argument that you and the defense attorney are making is that's super, but how about some evidence?
Yep.
How about it?
Well, we had asked for it and it was not allowed. So I think it's an option the court can consider. It certainly would be more in compliance with the rule. And maybe if he's not able to abide by that, then maybe there's no other possible remedy, but it seems like there is an option now.
There's so many points in this journey, Mr. Kryachin, where it appears to the court that you believe court orders or the rules don't apply to you. And let me use each example.
Notice
so I'm
the
not just
word
telling you
used.
this
It
and having you say,
appears
well,
to
I
the
wonder why
court.
he would say that.
Not we have evidence of, or we have concrete, it appear, he even like using his own language, he accidentally admitted that he has no evidence. He said, it appears to the court. Language will always give you away. And the judge literally, I mean, you can't catch it. You'll never be able to catch it in the middle of a hearing. That would be extreme, obviously. Or like when you're on fire like that in a heated argument with the court. But the word that he used, it appears to the court, literally just gave the guy away. That he literally has nothing other than suspicion.
Just get a parole officer in there to say that they're not complying with the terms. That's easy. They're gettable.
The easiest thing in the world, man.
That doesn't prove up the DUI, but you can prove the violation. But yes, how about some testimony? A person saying it,
Kentucky does it all the time. All the time. You'll schedule a probation violation or a probation revocation hearing. They bring in the PO, they take the stand, and as soon as they take the stand, you look at your client and go, yeah, you're probably going to jail today. Just brace yourself. Before the hearing starts, because they're going to build the record and the judge will go, what's your argument? And you'll throw everything you've got and the judge will go, okay, thank you for that, counselor. 60 days in jail, I think, seems reasonable. What do you think, Mr. Prosecutor? Sounds reasonable to me, Judge. I would lock him away for longer. And the judge goes, okay, well, I'll do 60 days and then we can revisit the case. Take him away, bailiff. And that's it. And your hands are tied. You got nothing because they screwed up. They brought in the proof. They testified about the proof. It's in the record. Judge made a decision. And I don't understand what the hell's going on here. What is Washington State doing?
You'll see that's what it gets down to is let's get a witness.
When a person's charged with a DUI, especially if it's the second one they've had in 5 years, even though the other one got reduced, and a judge says, I'm setting bail for you, and you need to not drink, most people, that scares them enough. Yet it didn't, allegedly, because you came back with another DUI charge.
Oh, yeah.
Now, that usually really wakes people up. Either they say to themselves, I got some issues going on that I need to address, or at the very least, I'm going to follow the judge's orders so that I don't have to go to jail. Usually it's enough of a deterrent. Now, who knows during the pandemic, Zoom hearings or a bunch of people released from custody or cases not moving very fast. Maybe defendants aren't as scared as they were pre-pandemic about the fact that they could actually go to jail and this is real.
More hypotheticals.
Nonetheless, you posted your bail, you got out and you got on Scram. It looks like for, I don't know, about 10 months or so, maybe even maybe 9 months, there wasn't any issues on Scram. So maybe that was happening. Maybe you were thinking about the judge's order and maybe you were really taking your release conditions seriously. And then every 2 months, April, June, August, alcohol came up on this Scram and you had a reason that it came up. And saying the reasons out loud now, my friend throws beer on me, I wrapped a towel with alcohol because my leg was hurting and I was putting mosquito repellent on. We say those out loud, okay. But every time I left you out of jail. And still, I couldn't I couldn't get you to follow through with all the court orders because in November, I think that was the incident date, even though a judge had told you not to drive without an interlock, and even though it looks like the DOL is saying your license was suspended, of course, you may get found not guilty at that trial. I don't know. There's allegations that you drove. So what this looks like to me is that you don't think the rules apply to you, and you find all sorts of reasons why you're going to do what you're going to do.
Yes, this is exactly what you're saying, though. I think he's a smart judge. I think he's a good judge. But ultimately, he's pissed because he was super nice to the guy and the guy wouldn't accept it. I understand it, but it's emotional. It's not the law. He's like, I'm doing everything I can for you, but you will not accept my help. I appreciate that, Judge, but no, he won't.
Right.
That's what's going on. He's mad because he so doesn't want to lock the guy up. You know, but that's where he is.
I don't think the judges over the past 20 years followed the court rule related to least restrictive conditions very well. Superior Court would set bail. Mr. Mullion knows this. He's had a long, distinguished criminal career on 2 states. He knows that they would set bail on every single case when we would read the court rule and say, well, the presumption is recognizance. And I think, especially in district court, we are trying to set release conditions, especially during the pandemic, that are way less than we've ever set in the past. Yet for you, it didn't work. And it hasn't. So this is...
Actually, this brings up, and I just wanted to ask you this too. If you're doing like DUI defense, you're going to really have the gamut. You're going to have hardcore sort of alcoholic problem people who just can't stop. And then but it's a crime that certainly you're going to have that element, but just, it's a crime that like almost anybody can, like your average Joe could just be like, I had too many that night. I did.
Sure.
How does that break down? Like in terms of your client base? I mean,
you mean like the problem drinkers from the not problem drinkers, or which demographic of society are they coming from?
Yeah, I mean, would you say like half your clients are problem drinkers and half aren't, or yeah, you know?
No, honestly, it's way less than that. I would say about 25% of people are innocent completely. They're just wrong place, wrong time, asshole cop, whatever. 5%, again, I'm just pulling these numbers out of my butt.
Right.
25% are problem drinkers who truly have an issue of an alcohol problem. It probably is even less than that. And the other 50%, it basically is an isolated incident, had a devastating life event. You know, somebody passed away, divorce, their significant other cheated on them. That is the largest majority. And in the second 25% is where all the second offenders, third offenders, fourth offenders, the problem drinkers, you know, they're all in there. But about 50% is just isolated incident, wrong place, wrong time. I shouldn't have done this. I had something happen to me.
That is fascinating on that level. It's just it's like, it's a serious crime. Like you don't get murderers across the spectrum. Like that tends, I mean, occasionally someone gets upset, but generally speaking, that tends to be criminal, right? Well, but literally like DUIs, like you'll see, I mean, anybody from any walk of life, from a homeless guy to a billionaire, to a doctor, to a lawyer, to a judge, anything, anybody like might do that like once in a while. They're not doing it 5 times, but it's a mistake literally most of the population is capable of.
And we represent a lot of professionals, and I get phone calls. I get phone calls from judges. I get phone calls from prosecutors. I get phone calls from other lawyers asking me questions about this kind of stuff.
Yeah.
So I had a prosecutor the other day, by the way. This is actually a pending case I got going on. He said, I have more leeway to negotiate with you in a murder case than I do on this DUI case we have. Isn't that insane?
Ooh, depends on the circumstance too.
It's a run of the mill DUI, no death, no injury.
It doesn't matter. You know what? All you need is that a recent horrible death from a DUI, unrelated to your case, and
he quoted a
it is
statute
tough to get a deal at that point, right?
I see what you're saying. Well, but he's right. He's right. The legislature did everything in their power to tie prosecutors' hands together to prohibit them from just handing these out like candy, so that the state can make their money and to keep these alleged drunk drivers off the streets. Which again, I'm not. Anybody who's talked to me more than 5 minutes about this stuff knows. Obviously, I'm not pro drinking and driving. Right. I am against drinking and driving. I tell people all the time, put me out of business. Put the DUI guy out of business. Remove all drunk drivers off the streets. I'm just going to go on and do the next thing. Right. I am only here because there is a problem in society, and that's drinking and driving under the influence. And I am here to help solve it and protect people's rights while I'm at it.
Yep.
Absolute mess of situation. And I could never get through to you. Even when I gave you the benefit of the doubt, those other 3 occasions when the Scram device tested positive, I gave you the benefit of the doubt. Yet, and maybe I was wrong on me, because maybe that made you think, well, whatever. I'll just do what I'm going to do.
He says that like,
by the court.
He's like, maybe it's me. I'm like, it is. And I like him, and I think he's a bright judge, but he's just like, he's too nice. It's that simple. That's his fault. And he's just like shocked that works a lot of times, but it does not work 100% of the time. Being nice, sometimes it fails. And here's a case in point.
I did not want you to get charged with any new criminal offenses. That has really put us in a difficult position. And I understand why you left, but we still have to deal with it. So your speedy trial in the 9Z case commences on 3/28.
It's a 19.
The speedy trial in the XC case commences on 4/4, although I think it can be argued under the court rule that that is an unrelated incident, and so speedy does not commence on that case until the completion of the 9Z case. And then I really think it can be argued on the ignition interlock DWS2 case that speedy is told until the outcome of the 9Z and the other DUI case. So the release conditions are as follows. You're still out on your own recognizance on the ignition interlock and DWS2, the newest case. Not a pretrial release violation. Recognizance, not an issue. On the 9Z case, I am going to revoke your $10,000 bond for all the reasons that I've stated.
Hello.
How's it going?
Larry, this is Keith. Keith, this is Larry. He is a public defender.
What's up, Keith?
In Michigan. He sits in 3B, sometimes in Judge Middleton's courtroom.
What's up, brother?
Living the
Sorry,
dream.
I didn't see you down there. I'm happy to see you, Keith.
Oh, it's all good. I've been watching and enjoying. Let's see where
What
this is going to go.
What did you think about all this? Did you have problems with the lack of evidentiary hearing here?
Yeah, I mean, you can't just woulda, coulda, shoulda, maybe sometimes woulda.
Yep.
Listen to this guy. Listen to this guy right here.
I could think of a host of things maybe I coulda, woulda, shoulda done. Maybe that I want to do.
All right, well, let's see how it plays out.
I'm going to impose on that case a $20,000 bond. And I'm going to put you back on Scram. And I've had some time to think about this too, because Scram didn't work before. I am going to authorize 2-watch monitoring if your Scram device tests positive for alcohol, that that day or the next business day, you are to go to 2-watch monitoring and take a UA. Because
do you guys even know what that is? I mean, they might be calling it something different in Washington State. What's 2-watch monitoring? I don't know.
It sounds like it sounds like maybe you might be referring to a company or a service that they have, and it sounds like a color system.
I just realized what UA is. I think I do. It's either urine analysis or a urine assay or something like that. I think that's what it is.
Okay, so like, but the Scram unit's on you constantly. So he's saying, okay, if that triggers, then you got to go do something else immediately, probably to confirm the test. So we don't get the bug spray arguments, I think is the idea.
Yes. That's to prevent that from happening a fourth time.
Keith, were you here for the I applied a alcohol home remedy on my body argument?
Guys, I got one on my back right now.
If I would have had a UA along with that Scram violation where you said a friend threw beer on you, I would have known whether or not you were drinking. So
yeah, he wants double
if the Scram device detects alcohol, 2Watch is going to call you in that day or the next business day to come in and take a UA. We're going to have two pieces of evidence to see whether or not you've been drinking or whether or not I have to hear some other explanation that I'm not sure is truthful. You're still required to have an ignition interlock device in your vehicle, just as you have been since 2019. That condition's never stopped, whether you forgot it, whether you decided you want to do something different. You cannot drive a motor vehicle unless it's first equipped with an ignition interlock device. And I believe that we should probably set that case for trial. This is the case where that trooper's not coming to our suppression hearings. You still certainly have the right to have a suppression hearing.
Here's the problem.
And Mr. Mullion, if I've been thinking about this.
What are you thinking?
What the fuck?
Did he just say that?
No, that's a dismissal of charges, man. You move for GD dismissal.
It's the trooper not showing up.
Done. Out.
With prejudice. That's it. That's a win.
Yep.
From your perspective, since earlier this week, I mean, you have the same right to subpoena that officer to be at that hearing. And I'm trying to think if I was in your shoes and this trooper had not.
He's asking the defense. Oh, this is rich. He's asking
their own client
to subpoena the trooper, and the defense does not like this idea at all.
Just went off the rails.
Like, wait. I have to subpoena somebody for you to prove their case? Oh, yeah.
Appeared for at least two suppression hearings. And at that point, the court may take different action if the trooper doesn't come. So the day we pick, we all know about that. The trooper got notice of it, and I think a subpoena, at least was on the prosecutor's witness list. That's about the only other thing I can think of.
Both of you guys have great expressions. Like,
I'm about to die. I'm literally about to pass out from high blood pressure.
Two different prosecutors have been ready to argue.
You don't like the judge imposing the notion of having to subpoena the trooper to court?
Not unless the defense attorney is getting paid for by the state under the table.
When you're the president, you don't invite John Wilkes Booth to go to a show with you. What is?
Yeah,
like
absolutely.
And their trooper hasn't been there. That was Miss Van Ness, and that was you and Mr. Nichols earlier this week. I know your position about, we can just go off the pleadings or off the PC statement. So, Mr. Hamalian, that was the other reason that I was thinking that you may want to subpoena that trooper for the suppression hearing, because you indicated on the record that you wanted to cross-examine that trooper. And I indicated on the record that I'd never done a DUI suppression hearing without the trooper. And so if you'd subpoenaed that person and you said there's questions I wanted to ask that person and he doesn't show up, then I guess we have to take the next step. That's about the only thing I can think to try to get the trooper here.
He's saying because they filed a motion to suppress that they need to subpoena the trooper. I find that odd too, because whatever, I do civil, but I'm sitting there going, look, I want to suppress the evidence if they're going to produce it. If they're not going to produce it, I don't need to even suppress it.
The prosecution has the burden. If they send a subpoena to a witness that is a necessary witness for purposes of a hearing, and the witness fails to show, and you need to move for two things. Number one, they're going to move for a continuance. If they had sufficient time to procure the witness and there was no conflict stated on the record previously, they're going to ask the court, Your Honor, we need more time. if they have had ample time and the judge is going to go, look, I'm not giving you any more time, you ask for whatever you ask for in your suppression hearing to be granted by the court, which should be automatically granted by the court. That's the bottom line. And if you ask
Basically, default
everything
ruling
under
on
the
the motion.
sun and they don't have a witness, it's a technicality win. It's going to a UFC fight and your opponent didn't show. They're not going to subpoena your bloody opponent to go do a boxing match next Tuesday. You win. You get the belt.
In my context, if the defendant, the civil, if the defendant doesn't show up, I say, okay, fine. I want a default judgment. Let's set it for prove up. We'll talk about damages next week, but but liability is over. That's it.
Right. Exactly.
Understand, Your Honor.
Your Honor, may I add a comment about that? So, one thing I just wanted to bring up is that even given all that, the state still is not sure which facts that Mr. Hamalian intends to elicit that are different than the facts already stated. So
now he's trying to pre-try the case.
I'm glad you brought that up.
Oh,
Mr. Hamalian, you have another suppression motion pending with me. We were trying to find dates for you. We sent, I think, 4 yesterday, and I asked Ms. Ashburn to send another 4 today.
if he doesn't show up, put a motion.
Exactly.
It just kind of got me thinking ahead in case we have any of these issues on that other situation. You know, Mr. Riston pointed out earlier this week, the court doesn't have to grant a suppression motion, right? We do, right? I don't know if you've ever been turned down in Clark County District Court when you've asked for a suppression motion on a DUI. I never was. I can't imagine that you have been. Maybe you have been. But I've never turned anyone down. But maybe that's what I need to require of defense counsel in the future, not you specifically, but just defense counsel in the future. File a declaration that says what's in dispute, and then maybe the court has to make a decision about whether or not a suppression motion is warranted. Again, I want to give you a suppression motion in this 9Z case for all the reasons that you've mentioned before, but
I'm just judging by facial expressions. This is not going over well with the defense attorneys here.
Dude, a pre-suppression, mini-suppression, declaration of suppression, motion, pre-motion?
I'm feeling rather suppressed right now.
He's kind of flipping the burden to the defendant, is the way I see it.
Yeah, and this guy is going to set some extremely bad precedent for everybody who has to be in front of that judge in the future. That's really sad.
No.
Maybe that additional step of filing a declaration to counsel that says this is what's in dispute, and that way we can have that as an additional piece.
I'm happy to file a declaration if it'll make you happier, if it'll make you feel.
It's not about being happy.
It'll
He
make
just
you
wants
feel
to
more
go home.
comfortable.
Didn't I tell you
requiring a
this whole
hearing.
hearing started with, I just want to
I
go
mean,
home.
if that's what you want, I'll file it.
Yep. He has not convinced this guy. I'll file a declaration. Can he impose that on him?
He can do whatever he wants. Is it constitutional? I would argue hell to the F no.
No.
Right.
I have one in my office. It just seems like a waste of time, but it's fine.
Your Honor, if I can be heard
There it
really
is.
briefly on that.
Don't waste
He
your
doesn't
time.
feel like
Your
it's a waste of time, so it's why I bring it up.
He
It's
doesn't
not
feel
about
like
making me happy. He's
He doesn't
arguing.
feel like it's a waste of time because he can't get his trooper in here. But it's fine. You know, if you want me to subpoena a trooper to come in to a suppression hearing, even when the state carries the burden of proof, fine, I'll do it. If you want me to get out a declaration and sit down with the police reports and put down specifically what areas of the intrusion that I think are insufficient, I'm happy to do it. It's just never been required before. Maybe it has, but I've never had anybody object to it before. We have a suppression hearing. Things develop at the suppression hearing, sometimes that we don't anticipate, and the judge makes a ruling. It's the way it's worked for 20 years, at least in my experience. You want to change it? Fine, I'll file a declaration. Let's pick a date. I'll file the declaration. I'll get the subpoena issued, and we'll see if that makes him show up, and then we'll go from there.
Thank you.
Why?
I wanted to do it the way we've been doing it for 20 years too, but
Well,
this
why
trooper
aren't-
doesn't show up.
Well,
Who cares?
And you haven't filed anything that says Here's what I'm disputing. So then this prosecutor is
Yeah, if the trooper doesn't show up, it seems to me the defense moves to dismiss and it's over, despite the fact that this guy really needs to be convicted.
Why isn't the judge? I mean, if the people have subpoenaed the trooper, and the trooper doesn't show, why doesn't the judge set a show cause or a warrant for the trooper's arrest to drag him in if it's so important?
At the very least.
Because nobody likes the boys in blue to come in bracelets. That's why. That's the answer.
Mm-hmm.
making an argument that we have not heard in the last 20 years is we want to proceed at this suppression hearing without the trooper. You're acting as if I am wanting you to do these things, as I'm like, oh, let me make Mr. Hamalian jump through these hoops. I wanted to do the suppression hearing earlier this week with the trooper here.
Okay,
Did you still want to be heard on?
Yes, but it's the state's burden. Oh, God.
I just want to point out that I'm not asking for anything crazy. It is the rule that Mr. Hamalian has to provide an affidavit showing what facts are in dispute. And to just explain what my position was,
Yeah,
I think
I've never heard of that.
slightly different, and it may not make a difference as to what you said, Your Honor, is that it's not that has to be done for a hearing to take place. My understanding of the rule is if there are facts that are in dispute, then it's a right to have that hearing. There's no other question. But if there are no facts, then it's up to the court to decide if it's worth having a hearing. If there's no facts to dispute, why are we bringing in, and I hesitate to use Trooper Wallace as an
Isn't
example
that what
here,
a suppression motion is in the first place? A suppression motion, what is a suppression motion? Did any of these people go to frickin' law school, or what's going on here?
They've
A suppression motion,
got some local rule that
you outline with particularity what pieces of evidence you're asking the court to suppress. Why does it need to be accompanied by an affidavit? Again, it might be a local rule, but I think that's actually a violation of your constitutional rights right then and there for you to have okay, prosecutors and judges love to do this, by the way. Anybody who's in the chat right now, listen very closely. Prosecutors and judges want to get as many facts from you as they possibly can before you're actually like in the record, on the record. So they'll try different things like affidavits. They'll ask you questions. They will, police officers even, they'll ask you questions before they give you Miranda rights. And sometimes those things are admissible. So said the Supreme Court of the United States.
Issues, as we call it. That's it. They want to.
Yeah, roadside, So any reason to get data, intel, information from you at any stage of the litigation. So, affidavits, like I said, any pieces of paper where you admit certain facts so that they can go, aha, so this is going to be their strategy at trial. Whereas you have one goal as a defense attorney as much as you can. You want a trial by ambush. You want them to not know what your strategy is. But you can't fully go ambush mode, especially if there's a motion for reciprocal discovery filed by the prosecutor or the civil defense, the defense attorney in the civil case. But this is what they're doing. This is what they're trying to do, and it's sickening. It's disgusting, and it's making my stomach turn because what they're asking this person to do is to basically tell me everything that you plan on doing, so we can know about it, and then shut you down before you get a chance to ask any questions on it. That's
absolutely what's going on. I mean, that's what we do as a matter of course in my civil practice, but I will say it's fair in that, first of all, it's preponderance of the evidence, and both sides have that burden effectively. It's very close. It's different than the state and someone's liberty. You see what I'm saying?
Exactly.
We don't know, though. The only thing I'll say, and everybody's sort of defense here, is we don't know the format of his motion to suppress. I mean, if I had to file a motion to suppress in my jurisdictions, it's going to be delineated with some specificity, right? But there's a host of motions and stuff that we have blank basic forms, check a box, or heck, in some of the smaller rural areas, right? You ask a court clerk, hey, could you schedule this up? And nothing ever even goes on paper. I know everybody goes, oh, that doesn't happen, but yes, it does.
Yeah, it does.
Yeah, I mean, maybe that's the kind of situation they're dealing with. We kind of don't have the context as far as that. It'd be interesting to see what the actual motion was that was filed and how it got brought out. And maybe that's why these fireworks are there.
I agree.
I don't know.
I agree too, but
But the
affidavit,
judge is really leaning on that technicality.
that's where I have an
throw it
issue,
out
is the affidavit portion.
You're not wrong.
Yeah.
Yeah, no. Oh, this is kind of fun. Like, I whatever. I'll carry on. But I'm law nerding out watching you two, who know a lot more about this than me. But it's funny. Your facial expressions are just very similar at the same time. So you're like, oh no, that's not happening. Oh no.
Why are we bringing in troopers who are already down in numbers?
They're the arresting officer on a criminal case that can put someone in jail, Mr. Riston. It's not an inconvenience.
He's right here.
For a trooper to have to come to court and testify. And if I already granted the hearing under the rule. So if the court's going to grant it, and then the prosecutor's office is going to say, well, we don't really have to have our trooper here at this point, that's just not something that's happened in the past. And you need to understand that. These are arguments that I have not heard in the 5 years I've been a judge. I didn't hear them when I was sitting in courtrooms as an attorney. So this is not something that's always been happening. I just want you to know, I mean, you're hearing it from him, but you're also hearing it from me. Suppression hearings have been routinely granted under the rule. The court just grants them, because what you don't want to do is not grant something and have it be grounds for an appeal. And when we grant them...
I said I just can't believe they're actually having this conversation on the record in open court. It makes me want to cry. It really does.
Well, to the judge's credit, he did. I think he went too far with the defense attorney, but then he did give it back to the prosecutor. Like, the prosecutor literally made the argument, and I understand why, but it's a bad one legally. Why would we need a trooper here? To prove a case, you're putting somebody, you're taking someone's liberty.
And he already raised the bond. He doubled his bond from 10 to 20. He already did that.
Yeah. That's ultimately the frustration. You know what I think solves this? We'll go, but you know what I think solves this? The judge says to the prosecution's office, yeah, I know he's probably guilty as sin, but you don't have your witness. This is dismissed. He grants defense motion to dismiss because you're not ready. They get burned a few times and they go, you know what? We need to get the trooper in. That's the way it goes in most places, I would say.
The troopers have come, they've testified, they've been cross-examined by defense counsel. I haven't had prosecutors argue, hey, they don't have to be here because we don't even know what the dispute is. So that this is happening. I am now, Mr. Hamalian, trying to do my best based on his argument to say, I guess this is what we need to do.
And I will try and follow your best guesstimation. I want some clarification from the court, though. Counsel used a term that has a legal meaning to it, which is affidavit. You said declaration. I just want to make sure you want a declaration, not an affidavit.
My understanding is it's a declaration of counsel. Yeah, I mean, you're not testifying, right?
Well, that it doesn't have to be notarized.
I can quote the rule: an affidavit or statement as provided by GR Set 13.
You okay with the declaration, Judge?
Would you object if he does it in the form of a declaration of counsel that says these are the facts we're disputing?
No. At this point, he could write it on a napkin. I want to know what the facts are.
Set a date, please.
All right, J.K. Rowling.
I believe that we should set the suppression motion and set the case. If we need to move the trial date, is the 9Z case that ends in 393.
Okay. That was the guts of it. I'm
gonna click on that most recent document to see if it already has future dates for trial. I think it does.
I'm just going to put it towards the end so you can see what happens here. It just takes too long to get there. He violates, like you said, for being gone.
Oh, that's where I came from.
Is that a washcloth on his ankle?
Got some numbers that you want to get from there?
So here's the defendant.
Just leave it on. You get it.
He does have a good legal basis, I'll say, for this. They effectively admit the violation. So that is evidence from them directly. But that's all. It's just the thinnest thing. We've got a bond violation. That's it. Enough to put them in jail.
Unless you want to write it down now.
The possible. Great fun.
Write it down.
If he can post 10, he can post 20. Judge knows it.
Actually, this one of these is going to be the jail copy.
Both of those are the jail copies. Mr. Maloney, if it's okay with you.
I can get it.
Yeah, this is the jail
I
copy.
was wondering till the end if he was going to be able to post it like immediately or whatever, but apparently.
Can you link my channel? Somebody's asking in the chat if you could link my channel, Mike.
That's not pretty, but it'll work.
Yes, by the way, Keith, I don't know what I should say. He wasn't feeling the greatest for a while. He was booming, and then he's got new material coming out, and he's got Keith Stickley. Go over there, check it out. It's awesome. Like, subscribe, all that. DUI guy, I will put a link. If anybody who's around, Secret, McSquirrel, you know, Sam I Am, one of you. Put up the DUI guys link. I will also put it in the video. And he's taken over the world, so most of you know about him anyway. All right.
When I was in school, I grew up in a big Italian neighborhood. I didn't think the kind of community. I do a roll call.
What's he? You got cops on him. I don't know why he's signing something.
I never saw that before. I was like, oh, Python.
Yeah, it's funny. I was just like, probably some adopted kid.
Maybe he's drafting the suppression motion for the lawyer.
I think he's Venmoing the court the additional cost.
This is a frustrating one.
This defendant's name is the Machine. Any other? No, you guys don't get the reference. Okay,
I know the reference. Yeah, he's a great comedian.
Run out of juice.
Unlike the Machine, though, this guy is actually Russian.
That's right.
I feel bad because the guy's got a drinking problem. Other than that, he's reasonable.
Yeah.
If he's Russian, he might not.
It may just be business as usual. You call it alcoholism. I call it Tuesday.
Nope, I just want this for my. Okay, good. I'm hold it.
Think about it. During COVID, how much of that
I have
stuff
to show
would be
the end, though.
gathered on our hands?
Which I don't blame people, but my viewers got to see the end. They got
I'll
to see
email
it.
it to you with your permission.
That's fine. We'll get it out.
Thank you.
In the jail. We'll take it in the jail. Clean the property.
See you later, Python.
See you later. Have a good weekend.
You too.
I got your email, by the way, but did you email Control too?
I called them
Oh.
with my manager's recommendation. They keep a log.
Oh, okay.
So
All right.
So there you have
No
it.
worries, but I did. I got your email.
thank you.
All right.
No.
You go by Peter or Pete?
Hello. All right. How do I stop that one now? Well, thank you guys for coming out. I really appreciate it. I sent out invites, but that was fantastic because we had what I think is a good judge, but not on his best day, a good defense attorney, and I have two defense attorneys. You guys were cracking me up. For part of that, both of you guys were just like, oh no. I can't believe what I'm witnessing here. It was pretty cool.
Yeah. No, some of the stuff that happened there, man, two things come to mind. Again, what the hell are the local rules and why is the defense attorney asleep? Those are the only two things that were going through my mind the entire hearing.
Well, I thought it's frustrating. The judge is basically like saying, look, this guy's violated 5 times during the pendency of his first DUI. He needs to go to jail. I'm like, yes, but let's get an evidentiary basis. And it's, in my mind, it's incumbent upon the state, well, in my mind, also in the Constitution, it's incumbent upon the state to meet the burden, not the defendant to do via some local rule, get a trooper in to suppress what the trooper is going to say. It's that's out there. That's out there.
I don't
for
think
me.
that part can't be part of the actual local rule.
Yeah. I
There's
don't know
no
where
way.
they pulled them
I mean,
from.
that's Constitution 101. I don't even.
He asked the defense attorney to subpoena the trooper.
Well, I think he sarcastically said he could have. That was my take. Maybe he was actually.
You know what? It's not my area. I might have missed something, but I looked at that and I just thought something doesn't add up.
I mean, I guess he could.
I think maybe it was more like the local rule. No, he had to plead like. I think what it was is they were relying on local rule saying you need to have some affidavit with specificity on the facts or something like that.
Yeah.
And I think somebody in the chat mentioned, I don't know if it's accurate or not, but somebody in the chat said that the defense never filed a motion to dismiss. That was their problem.
Yeah. Ooh.
Maybe it can't be done early.
But that guy was sharp that they had today. I mean, he wouldn't miss it.
You know, and we don't know the facts with respect to counsel. It's very possible that the dude had a different lawyer this entire time, and this is the first hearing that this bulldog is in the courtroom with him. You know what I mean? So he's walking in. I've had cases like this where you're walking into a pile of shit and you're like, what do? I need to do whatever I can to salvage this, that the previous attorney has screwed up so much. You know, it happens. It's some family law attorney, you know, who never practiced DUI law in their life, has been on this case for 6 months, and now I have to pick up the pieces. It does happen.
Well, I thought, and you know, I'm really speaking out of turn here, but something that threw off a flag to me was that we're talking about speedy trial motions, and it's a 2019 offense. So what I'm thinking is, no, but that it's a latent speedy trial motion. You see what I'm saying? Like let's tie somebody up after the fact. Like it's not something the first attorney did, or what do they have? Like 180? I don't know. You guys tell me.
I don't know about Washington, but what I can tell you is more than likely it was what's the word I'm looking for, Keith? Help me out here. When they delay it because of circumstances, there's a term, I just can't think of it right now.
Outside of the whole COVID thing. I mean,
because of COVID, it was told. There we go. The motion requirement was told because of a national emergency. So
it could all be told. Yeah. Okay.
Yeah, it can easily argue that speedy trial motion is still in effect. It's just been told through, for 2 years.
We don't have that terminology here, at least in the jurisdictions that I practice in, but every single time that came up, and it did come up quite often, especially like in early 21, it was just like, nope, national emergency, nope. So I think I have like 7 jury trials scheduled in April that are all early 20 cases, late 19, 20 cases.
Wow.
Yeah,
it's gonna go. All right, you guys, thank you so much. I'm gonna do super chats real quick, but I don't want to take up more of your time on Friday night. It was awesome to see both of you, and it was awesome to see you guys together. So Larry, Keith, Larry, I'm building bridges here. The law nerd that I am.
This guy right here. These guys.
All right, I'm gonna do a little chat. I want to actually stop too because for Artie, whatever. I'll deal with that in a second. But thank you guys, and I'll talk to you later.
Hey, Larry, drop me a line.
Thanks for having me, Mike. Nice meeting you, Keith.
Yep, you as well, sir. Bye.
Bye.
All right. Well, hello. I hopped on because that went better than I thought. I didn't know I would get the guests. I was just going to do the clip, but that was super cool. Thank you all for coming out. I wanted to squeeze that in specifically before Artie. And then I saw something in the chat. I hope I wasn't stepping on Deborah, but oh Lord, if you guys weren't there yesterday, go watch Deborah's 5K live stream. It is deliciously awful. I mean, but you got to have the chat. You got to have the chat because Deborah and I can't talk for the first 10 minutes. I was on the thing. I watched it today. It was one of the funniest things I've ever seen. Because we couldn't talk to each other. The chat was hilarious. I really recommend it. Also, Artie's got a 10,000 special starting in just a few minutes. So everybody go over there and check it out. And thanks again to Keith and Larry for coming on. Let me see here. I don't know if I missed. Also, thanks everybody. All my new members. I just started that. I didn't even know. Or Randy, I see one, but I see a few. I was like, I'll just start it and then I'll figure it out. And then a bunch of people send up, and that is really, really sweet. I appreciate it. Supportive. People have been asking me that for a long time. I just put it down to you're just being nice to me. I have no idea what we're doing with the memberships, but it is really, really nice. I get it. You're being supportive of me, and I thank you for it.